A lot can make you die. Have you heard about that bird? You need to open up your eye. Truth can set you free. A lot can make you die. Have you heard about that bird? I can't remember the first act that I saw, but I can't remember this. I was years old, on my bike, you can keep in the hood. Then I'll leave it to the smoke, keep you know it's coming good. Pedal up the hill, then I ride down fast. Did it for the thrill, but it never did last. Did what I had to have a little fun. One thing led to another, got it. Now I'm on the run, that I can't afford to get caught. Now I'm on the run, that I can't afford to get shot. Watch my back, use my head, and it won't be long till I get ahead. And watch my back, use my head, and it won't be long till I get ahead. Setting the ways, repeating the days. Fuck with the lightest, I'm part of the face. I'm through it out, around it, or above it, or below it. The first affliction. Know it, life ain't what you think it is. When you've only got 5 senses. Gotta use your third eye to figure out what your 6 senses. For the 6, you get all obtain wisdom, understanding. Science is simple for the conscious mind. I don't think you're understanding. What do you know? You only think you know. Did he find out? Thought you knew. Did he find out? Thought you knew. See all, tell none, be about it, action, step up, be a man. Fuck that no shit, yeah you can. This time you gotta deal with it. Let them know everything is real with it. 70 ways to beat in the days. Fuck with the light is a part of the face. 70 ways to beat in the days. Fuck with the light is a part of the face. 70 ways to beat in the days. Fuck with the light is a part of the face. 70 ways to beat in the days. Fuck with the light is a part of the face. 70 ways to beat in the days. Fuck with the light is a part of the face. 70 ways to beat in the days. Fuck with the light is a part of the face. It's not.
We're just gonna finish listening to that trust video from last night.
Republic, and so forth. So, real good article for you to check out. Let's get back to our document. So as we're back, I want to one more time reiterate the importance of understanding the difference between public law and private law. Don't walk in anybody else's house. You need to know the difference between the two, okay? If you learn this fundamental information, all right, first, contract law, where it's at, where constitutional law is. You'll hear I've heard a lot of people come on and say, you're not party to the Constitution and things of that nature. And I'm going to show you a couple of things real quick, some case law. Okay, and here we are. This case is Jones versus Timmer. This is a very interesting case on standing and who has the authority to bring an action in an Article 3 court. Very, very interesting case that someone submitted to me. But in here was a very interesting site that you find that talks about the privileges and immunities clause. And you need to read this very carefully so you can understand what this public and private thing is all about. It says the privileges and immunities clause of the 14th Amendment protects very few rights because it neither incorporates any of the Bill of Rights nor protects all rights of individual citizens. See the slaughterhouse cases, and slaughterhouse cases is something we should be as well. Instead, this provision protects only those rights peculiar to being a citizen of the federal government. Semicolon. It does not protect those rights which relate to state citizenship. Alright? So it don't have nothing to do with the state. These people are telling you right here, you are a citizen of what? The federal government. Okay, that federal government is in that 10-mile square, which is in Washington, D.C. Okay, you'll see the picture start to talk. Now, we're talking about the 14th Amendment. Of course, that's constitutional law. So if you're party to the Constitution, you're on here, you're on this side. And let me show you something about this party to the Constitution as well. And here we are on a case called Barron versus the City Council of Baltimore. Now, this is a case that every American citizen should read, especially all of you people talking about my constitutional rights and get upset when I say you're not a party to the Constitution. What made you a party to the Constitution was the 14th Amendment. This case was prior to the 14th Amendment, as you can see, it was in 1833. Okay, and it is very interesting. It's chock full of information. It's a U.S. Supreme Court case, as you can see. It's on a writ of error to the Court of Appeals from the Western Shore of the state of Maryland. And let's read the syllabus, which gives the overview of the case. It says, the provisions in the Fifth Amendment to the Constitution of the United States declaring that private property should not be taken for public use without just compensation is intended solely as a limitation on the exercise of power by the government of the United States and is not applicable to the legislation of the states. The Constitution was ordained and established by the people of the United States. Now, this word people is something you need to look up in a Black's Fourth Edition if you want to get an understanding, because a lot of you think that you comprise the people. You don't. The people of the United States, for themselves, for their own government. Well, who are the people of the United States if the states are somebody separate? For their own government and not for the government of the individual states. So right here you see the government of the United States and the government of the individual states are two separate things. Each state established a constitution for itself, just like the United States got a constitution for itself. And in that constitution provided for such limitations and restrictions on the powers of this particular government as its judgment dictates. The people of the United States frame such a government for the United States as they suppose best adapted to their situation and best calculated to promote their interests. The powers they conferred on this government were to be exercised by itself, and the limitations on power is expressed in general terms but naturally and necessarily applicable to the government created by the instrument. There are limitations of power granted in the instrument itself, not of distinct governments framed by different persons and for different purposes. And if you don't understand that and let a judge, a Supreme Court justice tell you, I don't know what with it. There's some people probably gonna give me a thumbs down and argue with it, but they idiots. They just gonna keep, walling around in their own ignorance and think they got another answer for things. Well, these people are telling you what it is. All you have to do is understand public and private. And let me go on, because something else I want to talk about too, and it's out of the dictionary, and this is for constitution. Because people talk about constitutors and things of that nature. Let's look up the word constitution real quick, and I want to show you something very interesting about that particular word. Okay, and now we're back at the Constitution. Okay, and this is Black's Law 8th edition, and I want to show you something really interesting about it. Okay, now, of course, we have the first definition of the word, the fundamental and organic law of a nation or state, that establishes the institutions and apparatus of government, defines the scope of governmental sovereign powers, and guarantees individuals civil rights, not fundamental rights, and civil liberty. The written instrument embodying the fundamental law together with formal amendment. Now, I want to skip down to right here, this fourth sense of the word, which is parliamentary law. The parliamentary law is that law that governs legislatures, okay? And this ties into the Act of 1871 because it's called the Constitution of the United States. And a lot of people say it's deceptive, it's illegal. No, it's not. You need to stop saying that. You look ignorant when you say it. And I just showed you the statute that says that you need to understand separation of powers. You need to understand delegation of powers. And any other type of power that the government has. The separation of powers is the important one because they had the power to create that. They've always done this. You can get a William Blackstone commentaries, and it has whole sections on their own corporations and everything. Now government uses them for different purposes. Essentially, the other constitution for their organization, like a bylaw, and you'll see it right here. You see a governing document adopted by an organization for its internal governance. It don't have anything to do with you, and its external dealings. Now, this is just like a trust document. A trust document is for its internal governance, and it shows you how to do the external dealings. Same exact thing in trust. And it goes on, it says, the Constitution may be an organization's most authoritative governing document, but if the organization also has a charter or adopted articles of incorporation or association, then the Constitution is subordinate to them. If the organization has also adopted bylaws, then the bylaws are subordinate to and usually more easily amended than the Constitution. And let me check this out. The Constitution and bylaws are sometimes contained in a single document. And this is like, it's like the same thing with the Declaration of Trust and the Indenture Agreement are sometimes in separate documents and sometimes contained in the same document. You're going to find out this is a lot like the rap game. It's like how people be coming up with their own slang. You start calling things different things. This is what you're going to start seeing when you start studying it. There's a document called Woe Unto You Lawyers that you really need to check out, where this attorney, this is written by an attorney, he gets into the ridiculousness of the law. And I'm going to be putting out something in the future on that as well. But I want you to pay attention to parliamentary law and put that in your vocabulary and understand what parliamentary law is, okay? That is under Constitution. So when you're looking at this corporate United States, okay, and why they call it the Constitution of the United States, it is a document that it's like a commercial constitution. What I saw in a book where a judge called it a municipal constitution. They actually called it a municipal constitution because as I read, it was a municipal. They put it in the municipality of the District of Columbia. That's the only power that they delegated to them, the power over that area and all of their insular possession. So you've been tricked into contracting into this particular jurisdiction. And this is what you are striving to get out of. Now, if you're trying to get out of it, as it tells you in Revelation chapter 18, come out of her, my people, so you do not be partakers of her plague. Okay, well, that's something else. It's like, you're trying to get all the way out. You're not trying to take advantage of TDA accounts or anything like that. But if you're trying to do business within the United States, well, that's an entirely different matter altogether. Now, the document you see in front of you now is a quick breakdown of something that I put together to kind of illustrate how everything has been structured. And hopefully this will kind of help you put something in your mind's eye so you can see what's going on. Now at the top here you have the Constitution for the United States of America. Look at the difference between for and of. This is very significant. You should look those up in the dictionary. Here's the preposition of the Constitution for the United States of America and the Constitution of the United States. Okay, there is a distinct difference between these two. The one that you primarily see posted everywhere in the back of books, on the internet, and everywhere else is the Constitution of the United States. You're going to have to look very hard for this Constitution for the United States. I'll probably do a video a little bit later on that particular topic as well. But first I want to give you a breakdown. Now the organic Constitution, of course, you have the Article 1, Article 2, Article 3, the legislative, executive, and judicial branches of government, each having separations of powers and each forming checks and balances on each other. Each also have what is called plenary power within their own respective branch of government. They cannot interfere with the other branch of government. So in this house right here, Article 1, okay, they have something that's called delegation of powers doctrine. And also, because of Article 1, Section 8, Clause 17, they have plenary power over the District of Columbia. They can do whatever they want to do, basically, within their sovereign power. They created something called the United States, which is a corporation. You can see also at the United States Code, Title 28, Section 3015, the United States is defined as a corporation. It's also in the UCC. Let me show that to you real quick. Now we are in the UCC Article 9307, which is called Location of the Death Door. Very interesting. And we go on down to H, we find something very interesting. The United States is located in the District of Columbia. I know I'm going to have some people argue with me, but it's stacks and mounds upon case law that support this. But maybe I'll just go into a long dissertation on what is this United States, because they're tricking us with this word United States and its 3 different meanings and the application and senses, how they're applied in different situations. But they'll always tell you something out front. The United States is located in the District of Columbia. Wow. That looks interesting. Okay. So let's continue. Let me go back to my outline of the Constitution. So you see right here, this legislative branch, what they did was the Act of 1871, they created this corporation called the United States. Now, this corporation also has legislative power, executive power, and judicial power within its own branch. Obviously, they have judicial power because they have a legislative court system. That's Article 1, Section 8, Clause 3. They have executive power due to their delegation of powers doctrine, where they delegate some of the legislative power to the executive agencies of government, such as the Department of State, Department of Treasury, Department of Defense, Department of Justice, FBI, Department of the Interior, Department of Agriculture, Department of Commerce, Department of Labor, Department of Health and Human Services, Department of Housing and Urban Development, Department of Transportation, Department of Energy, Department of Education, Department of Veteran Affairs, Department of Homeland Security, and United States Secret Service. These are all executive agencies. And there's supposed to be a separation of powers doctrine that they have to abide by, but they're delegating power to them. It's called delegation of powers doctrine. Judge Antonio Scalia, he did not like this at all. You know, he says he feels like it's unconstitutional. And I'll play this little short video for you just to show you what I mean real quick.
Thank you, Justice Scalia and Justice Breyer, for joining us. It's an honor to have you here today. Justice Scalia, I wanted to follow up on some things you had said in your opening statement, along the lines that it is and properly should be a difficult, cumbersome, time-consuming process in our constitutional republic to enact legislation. I think the courts can and should play a significant role in ensuring that that's always the case. The court certainly has played a role in the past, in cases like INS v. Chalk, in which the court has stepped in and said, you know, notwithstanding the fact that you, Congress, may have found something that makes the process of legislating easier or perhaps even more efficient or collegial, you haven't dotted your I's and crossed your T's in the same way that we contemplated under Article 1, Section 7, Clause 2, requiring bicameral passage and then presentment. And so this provision is invalid. So let me ask you the question, is there also a role for the courts? Can you foresee a role for the courts in other situations in which Congress, some future hypothetical Congress, might do something different that would prove easier and more efficient and more collegial, but perhaps in a way that's antithetical to the Constitution? For instance, let's suppose that Congress, when legislating on the delicate and pressing issue of maintaining the proper records in the dog breeding industry, since we're talking about federal legislation, these would of course be dogs either moving in commerce or taking advantage of some channel or instrumentality of interstate commerce. But a law in which Congress just passes a law saying we're outsourcing, we're delegating the authority to regulate dog breeding and record keeping for purebred dogs to the Board of Directors of the American Kennel Club. That passes both houses of Congress. It goes to the President. It's signed into law. And we then have outsourced the regulation of this practice to the American Kennel Club. Is that a situation in which you can anticipate the court might step in?
Well, I would step in. I don't know if the court would. I was the dissenting vote in the first case involving. I hate to mention this, but my friend Stephen here, since he was on the Sentencing Commission, I thought when Congress created a Sentencing Commission to decide how many years everybody should spend in jail, because presumably Congress didn't have the time to figure it out for themselves and usually do it. I didn't think that was constitutional. So I'm sure I wouldn't like your dog breeding body either. I can't speak for the court. I don't know what the court would do.
But for you personally, looking at it, notwithstanding the fact that it's more efficient, notwithstanding the fact that you do have bicameral passage and you have presentment of this hypothetical law, the problem is that you have delegated lawmaking power.
Exactly.
And
exactly. You have to be careful because John Jay I just read this in John Stevens' book. It's pretty good. The first chapter, it says, John Jay, first Chief Justice. And George Washington went to him and said, I have a lot of questions here. I don't want to do anything unconstitutional. Here are a bunch of them. Will you answer them? And John Jay said, no advisory opinions. Not giving any reason, of course, as he didn't know the answer.
And he was right. He
Yeah.
was right. And his tenure on the court proved to be short-lived in any event.
Now, the situation you pose is quite different, of course, from your leaving it to an agency.
So how is it different then? How do those differ?
Well, because when you leave it to an agency, you are giving it to the executive. The executive can make rules. You can't run a president. Your competitor, the president. The separation of powers with different branches competing. And there is no such disincentive when you leave it to this private group that you're talking about. That is just a pure delegation of legislative power. You are not authorizing an executive to act like an executive, but you are delegating legislative power to a group that has no executive responsibilities.
Okay, and now I'm back. Okay, so you can see right here, the judicial power that is exercised under the legislature pursuant to Article 1, Section 8, Clause 3. This is why you have what is called Article 1 court. Now this is coming out of Black's Law 8th edition, all these definitions. And you can see it says see legislative court under court. It's a type of federal legislative court that is not bound by the requirements of or protected under U.S. Constitution Article 3, Section 2, and that performs functions similar to those of an administrative agency, such as issuing advisory opinions. And this is also where you get into the admiralty, because these administrative agencies, that's what they're doing, they're enforcing admiralty upon you. And they're telling you it's not really a court, it's an administrative agency. I keep telling people this, even in the, if you're in federal prison and you catch a shot, okay, they go and you have to go get your counselor to represent you. You go before a board, okay, then they find you guilty and then they put you in a hole. That's called administrative law. Well, they're doing the same thing when you go into a federal court. Okay, this is a violation of interstate commerce and they're administering something against you. They're using administrative law against you. If you read administrative law, you will see everything that they're doing in the courtroom. It's not a real court. It is an administrative court. They're telling you right here. And the expert commentary, it'll get into it and explain it a little bit more right here as we can read. And it tells you. Congress also has power within certain limits to create what are called Article 1 tribunals, and that is Article 1, Section 8, Clause 3. These Article 1 tribunals are really akin to administrative agencies. Notice they use the word really. Like they call it an Article 1 tribunals, but what they really are administrative agencies. That is, the judges do not have any constitutionally guaranteed lifetime tenure or protection from salary diminution. Now, here's the trick. They'll say, well, it doesn't have the quality. The judges over there don't have the quality of an Article 3 judge. Well, separation of powers tells us two distinct things, man. This is why they kind of try to give you an explanation that doesn't quite explain it to you. We know that these Article 1 judges are elected and appointed into office and so forth, and they have a term, and that real judges have a lifetime tenure, you can't affect their money. That's only one quality of it. You got to look at what these people are trying to do with your mind and everything, get you thinking a certain way. They're not governed by the case of controversy limitation of Article 3. At the present time, Article 1 courts include territorial courts, certain courts of the District of Columbia, courts martial and legislative courts, and administrative agencies that adjudicate public rights. And this is the thing that I'm saying with all of you out there listening, is a lot of you do not respect the public. The public has rights, okay, and you are not in the public, you are in the private. And you have to respect the rights of the public and you want them to respect the rights of the private. And for you to know what the private is, you got to find out exactly what the limits of private rights are, so you will not cross over that line. It goes on. Let's read what something else it says. This is coming out of Black's Law 8th edition as well. When acting to enforce the statute and its subsequent amendments to the present date, the judge of the municipal court is acting as an administrative officer and not in a judicial capacity. There's a semicolon that gives an explanation. Know your rules of grammar, arguments, and rationale now for that of the agency. Additionally, courts are prohibited from substituting their judgment for that of the agency. Courts and administrative issues are prohibited from even listening to or hearing arguments, presentation, or rationale. Okay? And that is because Article 3 judges the separation of powers. All this is tied in the separation of powers. You need to understand separation of powers, everyone, if you're going to understand what is going on with your court system, and also if you're going to understand the Act of 1871, you need to understand separation of powers. All these things that you see all these people on the internet talking about, but they're just sitting on there talking, but they're not pulling out things and showing it, explaining this to you and everything. You need to find this out for yourself and do your own research. Stop sitting on your behind and listening to what these people are saying, because most of them don't know what they're talking about. They say, no, they're talking about the government is stealing. The government is not stealing anything from you. What it is that you turned your back on the Creator, and you're putting all of your hope in men. Okay, and that is what this whole game is about. It's showing you that that is a fallacy to put your hope in men. The only thing that you can put your hope in is something that is immutable, meaning it's something that doesn't change. Something that doesn't flip-flop like the wind, something that is stable, and that is the creator of the balanced universe and the laws that he was implemented to regulate everything in creation, called nature. You got to get back to nature. I'm your surveyor. I produce radio. Peace to the God. I'm out.
So you got to get back to nature.